Bom dia. Good morning, everyone. As you know, these sessions will all be in English. It's our great pleasure, mine and Professor Rafael Neves from Unifesp, who was a guest professor at this year's graduate course on Law, Power, and Liberty, where we read Professor Dysenhaus' work. It's our great pleasure to welcome Professor David Dysenhaus here for 3 days of lecture with us. I would like to thank you all very much for coming. I know we are sort of getting into the Christmas spirit already, which will last until Carnival. It's the longest Christmas spirit ever. I would like to acknowledge your coming here today. It's a very unique opportunity. We have some of the graduate students are here, Renato, Gisele, and we had the chance to read Professor Dysenhaus's book, and we have this very unique opportunity to discuss our readings with the author, of the book. And so it's something very unique, and I thank you all for being here and taking the chance to be part of this. We are broadcasting this live through the university's YouTube channels. The camera is right there. You don't have to worry. You're not in the camera. But you do have to speak on the microphone if you have questions, because people have to hear you. Okay? So thank you very much. I will give the word now to Rafael, who will introduce Professor Dysenhaus.
Thank you. I'd like first to thank Professor Mafei for the generous invitation to teach a class with him on the role of the judiciary in weak legal systems, starting by Lisa Hilbing's book on Chile, and then Professor Dysenhaus's book on South Africa. In difficult times, as the one we're living now in Brazil, I think the role we as academics have is to try to think and discuss at the highest possible level. I would take that as a duty, to think how to get us all out of authoritarian pitfalls. But talking about high-level intellectuals, let me have the honor and pleasure to introduce Professor David Dysenhaus, Professor of Law and Philosophy at the University of Toronto. He studied political theory and law at the University of Witwatersrand. I think it's more. Okay, also known as WITS. Yeah, under the apartheid regime, whose own mother was a black sash activist, was influenced by another great law professor, John Dugard. He got his PhD at Oxford under the supervision of Ronald Dworkin. His dissertation, I have here the first edition, I hope he could sign for me, whose second edition we had the opportunity to read with our students this semester, is an attempt to show how, despite all segregation and inequality under apartheid rule, law did provide some kind of resource for resisting weak to law. So it was possible throughout apartheid, even during the worst days, to bring legal challenges against the manner in which apartheid law was being implemented. He has also written on the Weimar Republic and its jurists, constitutional law, legal theory, and political philosophy. He has taught at several universities around the world. Thank you very much, Professor Dysenhaus, for being here today.
Okay, well, thank you very much for that most generous introduction. I'll certainly sign your book after that. And thank you all for being here. I understand this isn't a time of the year where you normally attend lectures or classes, so I think a special effort has been made to attend this seminar today, and I will try to keep you interested for the time I'm going to talk. And after that, I hope that you will talk to me, because I'm going to just talk for some of the time, and then we will have an opportunity to discuss things. So as you just learned, I come from South Africa, and that means that you have to struggle not only with a language which isn't your native language, but also with my South African accent, which I haven't lost, despite the fact that I've lived outside of South Africa now for much more than half my life. And I do know from talking to audiences whose first language isn't English that somehow the South African accent with my flat vowels makes it very difficult sometimes for people to understand me. And so there's a second warning that I have to give you, and that is that when I get excited, and I still get excited about these topics, even though I've been working on them for all of my academic life, I tend to talk too fast, and the man on my left, Rafael, is going to try to slow me down if he perceives that I'm getting out of control. But I will try to keep to a reasonable pace. So my topic for today is legal theory and judicial obligation in wicked regimes. And as you all know, because you all have acquaintance with the main topics in philosophy of law, the two main camps in philosophy of law are, on the one hand, legal positivists, who say that law is merely enacted or positive law, and hence they conclude that there's no necessary connection between law and morality, known after H.L.A. Hart as the separation thesis. So that's the one camp. And the other camp is the natural law camp, which argues that in some way law has a moral quality to it. And the main figures, at least in English, in the natural law camp in the 20th century, although they sometimes haven't claimed the label a natural lawyer for themselves, are Lonnell Fuller and Ronald Dworkin, both American legal theorists. So I'm going to use these two camps as the kind of foils in my presentation today. On the one hand, legal positivism, on the other hand, natural law. Now, the talk is about judicial obligation in wicked regimes. And if we mean by judicial obligation, the moral obligation to apply the law as it is, the law as it is found, then the answer to the question which of these camps is correct when it comes to philosophy of law seems to be obvious. Because in a wicked legal system, it seems obvious that judges are not under any obligation to apply wicked law, if we mean by obligation, moral obligation. And since there have been wicked legal systems, systems which have been dedicated to the pursuit of injustice rather than justice, then it follows that legal positivism has to be right. That is, that there's no moral quality to law just because it's law. But I think that when this kind of claim is made, and it has been made and continues to be made by people within the legal positivist camp, there are two assumptions that lie behind the claim that it's important to bring into view, to make two assumptions which are often implicit, explicit. And the first assumption has to do with a certain picture of natural law. The picture of natural law goes as follows, that what a natural lawyer does is first establish the standards of correct morality. So we first find out what the true standards of morality are. Then we isolate the most important, the core values of this morality. And then if positive laws or enacted laws violate these standards, then they are not law for that reason. So valid positive law ceases to be law if it is extremely unjust. And this is a position that's often associated with the German philosopher of law, Gustav Radbruch, whose work is sometimes summed up, I think mistakenly summed up, as saying that extreme injustice is not law. So that's the picture of natural law. The second assumption, and it's related to the first, is about the way that the problem of the connection between law and morality should be framed. So this assumption is that the problem is that we have, on the one hand, a valid law, a formally valid law, and this formally valid law has a determinate content. We know, in fact, what that content is, and we know that this content is wicked or immoral. And because this content clashes with the moral standard that deems this content to be immoral, there's a problem there. And that's the problem that legal theory faces. But I think this assumption, if we pose the problem in this way, is one that presumes a static model of legal order. That is one in which law is, rather than law is in a process of becoming. Law is already determined on the static model. And so then the issue is, what should we do about law which is valid but has a determinate immoral content? And because it's a static model, it's obvious it's not the kind of model that I think we should have, which is a dynamic model of law. Now, if one makes these two assumptions, then law is, as we might think of it, morally inert. Law in and of itself has no moral quality to it, and it only becomes morally active if it happens to if its content happens to coincide with morality. Now, this creates a kind of strange alliance between the picture of natural law, which I have suggested might be a mistaken picture, and legal positivism. Because if one holds these two assumptions, then the debate about judicial obligation in wicked legal systems is a futile or useless debate. Why? Because on the one hand, legal positivists will say that a judge in a wicked legal regime should not apply the law because it's morally bad. On the other hand, a natural lawyer will say that a judge in a wicked legal regime should not apply the law because the law that is wicked fails to be law because it's wicked. So they come to the same practical conclusion, that natural lawyers and the legal positivists, and hence we need not bother with the debate about wicked legal systems and the obligation of judges in such systems. And in a way, this conclusion is embraced by the person who you learned was my former supervisor, Ronald Dworkin, in his very last work. So in his last work, which is called Justice for Hedgehogs, in the very short chapter in this massive work of really political and moral philosophy, in the very short chapter on law, Dworkin says that the debate between legal positivists and natural lawyers about the problem which I'm talking to you about today is just a verbal dispute, because legal positivists and natural lawyers have the same view about what judges should do, that is, they should not apply wicked law. Now, I think it's an interesting fact about this short chapter on law in Dworkin's work, Justice for Hedgehogs, that there wasn't even a chapter on law in the manuscript of this book. And Dworkin had a symposium on this book at Boston University, which was then published in the Boston University Law Review. It's a massive symposium, maybe 500 or 600 pages of comments on the manuscript. And then Dworkin revised the manuscript in light of the comments in the Boston Law Review. At that symposium, a very well-known philosopher of law, David Lyons, who'd been debating with Dworkin over many decades, raised the problem of wicked legal systems for Dworkin yet again. And so made the challenge that for Dworkin, it's the case that if he really thinks that judges are under a moral as well as a legal duty to apply the law of their legal order, then he must reach the conclusion that judges in even a wicked legal system are under a moral duty to apply the law of that legal order, and hence there's a real problem for Dworkin's theory. And Dworkin was forced, because this objection had been raised in public yet once more, to respond to it in his last major work in political and legal philosophy, Justice for Hedgehogs. Dworkin, I think, never satisfactorily dealt with this objection, which is why he always reluctantly tried to deal with it when forced. Now, on the picture of legal positivism that I painted for you just a few moments ago, there's no problem for legal positivism when it comes to the issue of judicial obligation in wicked legal systems. Why? Because legal positivists will say law has no moral quality to it, therefore judges should not apply immoral law. But I think that this claim that wicked legal systems are no problem for legal positivism is a claim that can only be successful on condition that we do not understand law as a matter of authority. And as soon as one tries to understand law as a matter of authority, it is my view that the problem of wicked legal systems will loom large for that theory just because it's trying to understand law as a matter of authority. And so wicked legal systems do become a problem for Hart. Why? Because as I think you'll know, Hart's great innovation, or one of his great innovations in philosophy of law, was in 1958 in his famous Harvard Law Review piece, and thereafter in 1961 in the Concept of Law, to have moved away from his positivist predecessors, Bentham and Austin, who'd put forward a command theory of law. And one of the things that Hart said goes wrong with the command theory of law is, as he put it in the 1958 piece, that the command theory of law, which assumes that law is just the commands of an uncommanded commander backed by threats, the command theory of law supposes that law is a gunman situation writ large. And Hart says in 1958, law surely is not a gunman situation writ large. There's more to law than coercive threats. And what the more is authority. So Hart sets out then trying to explain law as a matter of authority. But if one puts that attempt to understand law as a matter of authority together with the claim that law in and of itself has no moral quality to it, then I think a problem arises for legal positivism, because it seems odd to have an account of law as a matter of authority paired with a claim that law has no moral authority, because then the authority of law seems to be morally vacuous. And that creates, I think, deep tensions within Hart's account of the authority of law. And these tensions only become worse in his great book, The Concept of Law, because there Hart makes it clear that the authority of law is constituted by what he calls the acceptance of legal officials, notably judges. This acceptance is of the fundamental rules of the legal order, notably the rule of recognition, that is the rule that certifies as valid the primary rules of that legal order. Now, Hart always emphasized that when it comes to judicial acceptance, this stance of taking an internal point of view, as he put it, towards the fundamental rules of legal order, that the internal point of view did not involve what he called moral endorsement. That is, judges have to have the internal point of view. That internal point of view is constitutive of the authority of the legal order, but we shouldn't equate that internal point of view with thinking that the legal order is morally legitimate. Why? Because there might be all sorts of other reasons why judges adopt the internal point of view, that is, reasons other than moral reasons. So we can understand what judges do in a legal order as a matter of legal duty without also supposing that it's a matter of moral duty. Hart admitted late in his life, in a book which I find fascinating, his collected essays called Essays on Bentham, that this account of judicial legal duty looks very odd. And it might seem, as put it earlier, even to be vacuous or empty. And I'm happy to talk more about this in discussion if people are interested in this set of ideas. But for the moment, I think I'll skip over this issue. I just want to mention one thing in a rather complex debate between Hart and his most famous student, Joseph Raz, in regard to this issue. Now, I don't know whether people are acquainted with Raz's work. So you'll know that Joseph Raz has perhaps the most influential theory of authority of the last, say, 50 years. And in this theory, Raz tries to generate an account of law from an account of authority. And in the process of generating this account of the authority of law, starting with an account of authority, Raz makes the claim that the law not only has to claim or necessarily claims authority, but also necessarily claims legitimate authority. Now, Raz is comfortable with making the claim that law necessarily claims both authority and that the authority is legitimate, because he thinks he can show that this claim is often not vindicated. While law necessarily makes the claim to legitimate authority, it will often or even usually be the case that that claim fails as a matter of fact because the law turns out not to be morally legitimate. Hart was very worried, though, about the fact that Raz had introduced this idea of legitimacy into an account of the authority of law. And I think a big difference between Hart and Raz is that Hart never puts his argument about law's authority in terms of a claim. Hart's argument is always put in terms of explaining the authority that law, in being law, has. Whereas if you say that law disclaims authority, then it might seem that when law fails to support its claim by actually showing that the authority it claims is legitimate authority, then law not only lacks authority, but ceases to be law. And I think Raz's position actually ends up deeply ambiguous between an extreme natural law view and a positivist view. But that's the issue I'm happy to talk to you about more in the question period if you want to talk about these rather esoteric topics. For the moment, I just want to make the point that for Hart, law has authority. And in making this claim, I think Hart comes closer to the way that judges actually think about law, even in wicked legal systems. And that, I think, is a virtue of Hart's theory. Because it is the case that when we look at judges in any legal order, whether it's a morally decent or okay legal order, or a legal order that we might think of as wicked because it's dedicated to the pursuit of injustice, we'll find that judges do think that they are under a duty to apply the law as it is. And they think of that duty not as something that's morally empty or vacuous. They think of that duty as a genuine duty. They think of that duty in a way that I think it's very difficult to make sense of, other than in terms of them thinking of it as some kind of a moral duty. Now, I mentioned earlier the two assumptions that I think lie behind legal positivism's claim about wicked legal systems, and that I wish to make explicit. And you'll remember that the first assumption is that the standards of morality that are relevant here are standards of morality that are somehow external to legal order. We first work out what morality is, and then we judge law against the standards of that worked out morality. And the other assumption is that we should adopt a rather static model of law in trying to understand what law is. And the question that interests me, which I want to talk to you about for a few minutes, is what happens if we think of the standards of morality that are relevant in philosophy of law not as external, but as somehow internal to legal order. And if we think about those standards as internal to legal order, then I think it becomes the case that our legal theory necessarily becomes dynamic, because it will be the job of judges within a legal order so conceived, that is a legal order with internal moral standards that have to be there just because it's a legal order. It will become the job of judges to try to ensure that the law of their legal order lives up to these internal fundamental legal principles. Now, on the legal positivists know about the attempts to show on the natural law side that the standards that are relevant to philosophy of law when it comes to talk of morality are internal to legal order. The first attempt to show why this might be the case in the 20th century is made by Lon Fuller, the American legal theorist I mentioned earlier. And are they familiar with Fuller? So I'm taking that everyone here is familiar with Fuller's claim that there are 8 principles or desiderata of legality that make up what he called an internal morality of law. And you'll also know that the way that both Hart and Raz responded to Fuller is by sometimes recognizing that there are principles like these principles of legality, but then making the claim that these principles make no moral difference, because they simply serve to make law more effective. And then, of course, if wicked law is made more effective, it's worse for that reason. So a system that lives up to the rule of law might be actually morally worse than a system that does not. So Fuller's attempt to show that their internal standards is widely taken to have failed. And it's interesting to note, I think, that Dworkin in the early 1960s, when Fuller first put forward this theory, attacked Fuller's theory with the same kind of aggressive attitude as legal positivists did. Dworkin fully joined in the attack on Fuller on the ground that these principles of legality make no moral difference. And because Dworkin agreed with this critique, he tried to develop a different, as he put it then in the early 60s, logic of legal standards, which resorted to an idea of principles immanent in the positive law. Now, you'll all know, so I'll just go over this very quickly. Dworkin's theory depends on an account of what judges do in what Dworkin called hard cases, so cases in which lawyers reasonably disagree about what the answer to a question of law is. And Dworkin argued that the way judges should approach a hard case is by looking at the positive law that seems relevant to the judge's decision, and then seeking to find out the principles that underpin that body of law that can make of that law the best that it can be, show it in its best moral light, and then the answer to the hard case is to be determined in light of those principles. And this is also a claim about the internal aspect of the moral standards. It's just that the internal aspect isn't found at the level of principles of legality. The principles are to be found in the positive law as it exists. Now, it's of course this problem, and those of you who were taken through the text, which was waved at you earlier, my book, Hard Cases in Wicked Legal Systems, will be very familiar with this idea. The problem for Dworkin is that in a wicked legal system, when one looks at the positive law that's available to the judge, it will surely become the case at a certain stage of development in that wicked legal system that the best explanation of why there are all these bits of positive law around that the judge has to make sense of is that these bits of positive law are underpinned by a scheme of principle that belongs to an immoral ideology. And in the case of the legal order in which I grew up, in which I first learned about law, the apartheid legal order, this claim was made, and I'll refer to this issue again in my talk on Thursday. This claim was made by a Dworkinian, a professor called Raymond Wax, who had taught in England for many years and been Dworkin's student, came back to South Africa in the 1970s to take a chair at a South African university. And in his first lecture, his inaugural lecture as a professor, he claimed that the liberal judges who were still on the South African bench, part of the South African judiciary, should resign because their duty as Dworkinian judges was to extend the ideology of apartheid in hard cases, because apartheid ideology best explained the positive law of apartheid. And I think this kind of claim poses a genuine problem for Dworkin's theory of adjudication and for his attempt to build a theory of law out of a theory of adjudication. And what I want to do in closing, because I don't want to talk for too long, is just to make two sets of observations based on my attempt to set up a kind of framework for thinking about these issues that I have proposed to you in the last half an hour or so. So the first set of observations has to do with my thought, which I've been developing in the last few years, that Hart and legal positivism are faced with exactly the same kind of problem that I just posed for Ronald Dworkin, that arises out of considering the question of judicial obligation in wicked legal systems. I didn't used to think this was the case. And I think that even in of this book, Hard Cases in Wicked Legal Systems, I continued to make the mistake of supposing that legal positivism was not faced with the problem that I've just suggested really makes life difficult for Dworkinian legal theory. I should mention, and maybe you know this, those of you who are in the class that read this text, that the title is actually lifted from Dworkin's work. I think it's a great title, Hard Cases in Wicked Legal Systems, but I can't claim authorship for it because it actually comes from a paragraph in Dworkin's work where he was attempting to respond to the objection that I've just sketched for you. Now, why do I think that Hart and legal positivism in general, are faced with this bigger problem when it comes to the question of judicial obligation in wicked legal system? So the problem, I think, arises most starkly if we look at Hart's 1958 essay in which he first introduced his understanding of legal positivism in English, and in particular to the debate that Hart had in 1958 with Gustav Radbruch, the German philosopher of law whom I mentioned earlier. Now, if you've read this essay, you'll remember that Hart is very concerned with the claim that Radbruch made after the Second World War, that legal positivism had helped the Nazis in their rise to power because legal positivism's slogan, law is law, made people think that just because this is the law, therefore it has some moral quality to it, and therefore as a judge, I should think that I'm under a moral duty to apply this law, or as a citizen, I'm under a moral duty to obey this law. And Radbruch, after the war, on Hart's understanding, says that because legal positivism encourages this attitude of compliance with wicked law, that we should accept that extreme injustice is no law, and so judges should not apply wicked law, citizens should not obey wicked law. That's Hart's understanding of Radbruch's theory. I think a completely mistaken understanding, but nevertheless his understanding of Radbruch's theory. And Hart thinks that this natural law theory, that extreme injustice is no law, is completely absurd on its face. So he just dismisses it out of hand. And in dismissing it, he refers to the work of his positivist predecessor, John Austin, and to a passage from Austin's work, which Hart quotes at length. Austin imagines the following example. A man has been convicted of a crime where the offense is either of doing something that's completely trivial or actually doing something that's been made into a crime, but that's of benefit to the society. So one imagines a society that has enacted a law that makes criminal doing something that is either not important at all, or actually something that one might think of benefit to a society. For example, makes it a crime punishable by death to give a few dollars to a person who's begging on the street. So we imagine a man who's convicted of this crime being led off to his death, and he protests that what's happening to him is illegal because the crime is so obviously absurd. And Austin says, your protest is of no use, as you'll find out when you're hanged. So that's Austin's response to this person who's being led to his death. And Hart fully endorses this claim on the basis that it shows us why the thought that valid laws fail to be law when they're extremely unjust is an absurd thought to entertain. So that's sufficient in Hart's view to dismiss natural law theories. But then Hart doesn't stop there, because he then goes on to try to put the final nail, as it were, in the coffin of natural law theory by dealing with a couple of cases that have been decided by post-war German judges, cases known as the grudge informer cases. So I don't know, will people be familiar with these cases? Yeah. So let me just quickly go over the grudge informer cases, or at least Hart's understanding of them. So during the Nazi period, statutes are enacted which make it a crime punishable in some cases by death to insult high-up Nazi officials. People are convicted of this crime and sentenced to death or consigned to some equivalent fate, like being sent to the Eastern Front. After the war, those who informed on those who were convicted of this crime are considered to have done something immoral, and an attempt is made to have these people convicted of having illegally deprived fellow citizens of their liberty, which is a criminal offense under a 19th century German law, which persists throughout the Nazi period into the post-war period. And the obvious response to this claim that people can be convicted of this crime for having turned in those who had insulted high-up officials in the Nazi regime is that this will be a retroactive punishment. Why? Because when the informants turned the people in to the Nazi authorities, it was perfectly legal to do so, given the Nazi statutes that made it a crime to insult Nazi officials. Nevertheless, post-war German courts find the so-called grudge informers, those who turned the people in during the Nazi period, guilty of the crime of illegal deprivation of liberty. And Hart thinks that the only way a court could have got to this result is by invoking what he thinks of as the Rudbrook formula, that is the claim that extreme injustice is no law. Therefore, these laws from the Nazi period, while formally valid, were not law because they were extremely unjust, and therefore there's no issue of retroactive punishment. And Hart thinks that this is crazy. He describes the German reaction to these convictions after the war, which welcomed the convictions as hysterical. And he says it would have been much better to approach this issue as a legal positivist, recognize that these Nazi laws were valid law, and then go to the legislature and ask the legislature frankly to declare that it was criminal retroactively to do what the grudge informers do and then convict them. That's the clean way of approaching this kind of problem, which natural law obscures. Now, I think that Hart's conclusion, which seems compelling if one understands these cases in the way that he did, seems a lot more shaky if one looks at the actual reasoning in the cases. If one looks at the way that the post-war courts in Germany reasoned, they did not claim that these Nazi laws were invalid. Rather, they tried to get to the result of finding that the grudge informers were guilty of illegally depriving the people they informed against of their liberty through a process of quite conventional legal reasoning. Sometimes this legal reasoning was rather strained, but in the cases in which I think it's less strained, what the judges found is that when the grudge informers turned, and was often husbands, into the Nazi authorities, they knew that when they were turning them in, that they were not turning them in to a legal authority. While there was, in some sense, a court process, actually what happened is if you turned someone in, that person would be found guilty and would be sentenced to death, because the German so-called judges in inverted commas, didn't think of this process as a legal process, but as a process which was designed to intimidate the population, and they played their role in this. In one of these cases, the judge actually informs the woman who's turning her husband in that if she continues to press the charge, he will have to find the husband guilty, and so she should think twice about it. So the idea, at least in some of these post-war judgments, is that this was a completely legal process. The people who were the grudge informers didn't want someone found guilty of a crime. They wanted someone put to death, and they could trust the process to issue in this result. And therefore, the grudge informers could be found guilty of illegally depriving the people turned in of their liberty. Now, I think this is interesting because it shows that at a certain point, a process, even though it presents itself as legal, might actually be illegal. And I think that's interesting also because in my view, judges are entitled to assume the legitimacy of their legal order as long as it is a legal order, not just a sham legal order of the sort that the Nazi legal order in large part was. And it's because there's some basis to that assumption that one can do one's moral duty in any legal order as long as it's a legal order, that I think it's not just a dangerous illusion, as legal positivists often seem to assume, to think that judges are under a moral as well as a legal duty to apply the law of their legal order. Why is that the case? It's because any legal order that's, properly speaking, a legal order is not going to be, as Hart put it in 1958, the gunman situation writ large. Why is it not the gunman situation writ large? It's because in any legal order, properly speaking, there will be in place the legal institutions that we are familiar with, that are often put in terms of the separation of powers. There'll be a legislature, there'll be judges, there'll be the executive. And as well as that, there'll be the principles of legality that ensure that the legal order is in good shape. So the principles of legality that Fuller attended to in his book, The Morality of Law, principles of legality which actually legal positivists like Raz have added to in their discussion of the same phenomenon. And as long as all of that is in place, I think it's the case that a judge in any case that's about the question what the legal obligations of those before the judge are, will be able to answer the question, which I think should be the principal question of philosophy of law, which is the question that I think the legal subject poses when the legal subject challenges the law. Why should that be law for me? If a legal order is a legal order, I think judges will be able to find the resources within their legal order to give an answer to that question, so that legal subjects can, at least in principle, be satisfied with that answer. And I think what this testifies to, and I'll be talking more about this topic in the lectures to come, but I'm happy to talk about it more, of course, with you now, hoping to talk about it more with you. The idea is that these moral resources are always available in legal order, as long as we drop the two assumptions that I spoke about right at the beginning. First, the assumption that the principles of morality are external to legal order, and second, the assumption that we should be operating with a static model of legal order. Because if we think of these principles as internal to legal order, then our theory, I think, necessarily becomes a dynamic one. It becomes one about the realization of those principles within legal order. And then the task of judges, the judicial duty, is to realize those principles. And the fact that there's a legal order in place will make it possible for judges to accomplish that task. I think I'll stop there and hope for some questions. Thank you.
Professor Dysenhaus, thank you very much for your instigating first lecture. As I had told some of you with whom I had previously talked, and also Professor Dysenhaus, the idea is that we are able to interact with him and ask questions. Many of us have questions pending from our readings of the book. Others might have questions regarding the future to come, and any other thing that you might. Conrado has a question. Rafael, you want to?
There's someone behind Conrado as well.
Sorry. Yeah. Murata. Hello.
Thank you so much, David. I have a very straightforward question. Legal theory during the 20th century considered weak legal systems as the basic 30s and 40s, and also South African regime as the basic historical background of their examples. We are in a new historical moment in which the problem is the democratic recession or democratic deconsolidation, or the emergence of what it is called illiberal democracies. So basically, I wanted to hear a bit from you, a bit of some elaboration on how do we certify in this new context what is a wicked legal system, and whether we can basically have a full sort of a full guideline for judges once we recognize this is illiberal democracy, what they should do, or this is more of a case-by-case consideration on the basis of a moral assessment of particular statutes. So, who is familiar with this literature already knows what the answer is, but I think in your presentation you didn't go into that direction in order to clarify how to certify a wicked legal system, and once you recognize this as a wicked legal system, do you have a full-fledged orientation for judges? This is the question. I'm not sure this is a clear question.
Yeah.
Yeah.
How would you rather we do this? Collect a few questions. Do you want to go individually?
Let's do it individually for the moment, because otherwise I'll just forget.
Okay. So.
Yeah. So as you heard, this is a very big question, which I tried to avoid raising during my presentation, and I think it'll be a question that might become more pressing during my presentation tomorrow. But I should warn you that I've tried to avoid it again on Thursday, and but it's not because I think this question should be avoided. And so, although we made the arrangement for me to come before it became clear that the person who was just formally made your president looked even likely, I think, to become your president, I know that the issues that I was going to talk about anyway seem very pressing for people in Brazil now. And as Conrado alluded to, these problems are pressing not only in your country, but they're pressing in the United States of America, where I just spent a semester teaching at New York University, and they're pressing in Hungary and in Poland. And I would like to think that they're not going to become pressing in Canada, but I think they will become serious questions in Canada, and to some extent have already become questions in Canada. So let me just give you one quick example. In Ontario, the province which I live in Canada, we elected in the last provincial election as our premier someone who looks like a mini Trump. So someone who's as far right in Canada as possible to be and be elected. And one of his first acts in office was in the middle of the city council election for Toronto to halve the size of, to propose a bill halving the size of the city council. And it's because he has a grudge, which is well known against Toronto. He hates Toronto because we're a bunch of elites. And so he wanted to kind of strike a blow against Toronto, and this was his way of striking a blow against Toronto. And immediately some concerned people from my city, Toronto, brought a court action to try to stop this bill from going forward, which is a difficult thing to do. And the Premier then said that what he would do is that he would invoke Section 33 of the Canadian Constitution. Now, you might know about this very interesting provision in the Canadian Constitution. It permits a Premier of a province or the Prime Minister of the country to override a judicial ruling of unconstitutionality for a period of time. Not in respect of all of the rights in the Canadian Constitution, but in respect of some of the rights. But no one ever thought in Canada that this override, which is very rarely used, would be used for as trivial a matter as someone succeeding in dealing with his grudge against a city council. And I think this is a sign of a kind of creeping authoritarianism within Canada that might gather momentum in the next few years. So just to say that I don't think Canada's immune from this problem. So I want to start my response to this question by recollecting something that was said to me when I first gave a version of the talk that I've given you now, which was actually at the university where I just finished teaching when I was teaching there the time before, which was in 2013. So I gave a version of this talk in which I tried to explain why wicked legal systems are as much of a problem for Hart's legal theory as they are for Dworkin's. And in the audience, visiting New York University at the same time as I was a retired judge of the Polish Constitutional Court, a very eminent Polish constitutional lawyer called Lech Golicki. And Golicki said to me during the talk that in his view, judges in any legal order will always have the moral resources to answer the question, which I said should be the question of philosophy of law. But how can that be law for me? A question posed by a legal subject to a court of law. And it struck me that this was a very interesting response by a retired Polish Constitutional Court judge, because Golicki was well aware at the time of the efforts in Poland at that time, which have since become much more determined to cut judges out of the Polish constitutional order in the same way as judges have, the role of judges in Hungary and in the constitutional order has been greatly diminished. And it seemed to me that one way of understanding Golicki's claim in support of my argument that judges will always have these moral resources available to them in any legal order, that claim is conditional on judges having a genuine role within the legal order. So one of the things that we see in these illiberal democracies is that in order to become substantively illiberal, so to become substantively unjust, if one thinks of justice as I think we should think of as informed by a liberal conception of political morality, they also have to become procedurally or even legally unjust. That is, they have to, as people like Orban in Hungary have very clearly seen, one isn't able to achieve one's substantive ends unless one gets rid of the procedural framework that's been put in place in order to achieve a substantively just society. So it seems to me that procedural and substantive actually hang together in this way. And for the same reason, I would claim that legal and substantive have an intimate connection. That in order for a system to dedicate itself to systematic injustice, it has actually to change being a legal order. It has to change from being a legal order into something else. Now, what can be done about this? So you suggested, I think, I can't remember if this is exactly your formulation. What is the kind of blueprint that comes from my theory for judges? Well, the blueprint is, might sound very simplistic, it's to keep doing their job as judges. Because if they keep doing their job as judges, and I'm happy to say more about this, but I don't want to prolong the answer to the very first question, eventually the regime that's in power will be forced to become entirely explicit about what it wants to do, as the regimes in Poland and Hungary are. That is, they have found themselves compelled to remove judges from being significant players in the constitutional order. And if they do that, and then it's really up to the population, because if people no more want to be ruled by law, then I think all bets are off. But I think that's the kind of limit situation that one reaches. But judges can do a lot to warn people that they are approaching this limit situation. And then the question becomes, well, what do ordinary Brazilians want? Or what do ordinary Poles want? What do ordinary Hungarians want? And that's the test. So there's no blueprint. Judges can't save us, but they can do a lot to help us to save ourselves.
Okay, thank you so much, Rafael. Then Daniel Mata.
Thank you very much, Professor Dysenhaus. I have two questions. One regarding the change that you made in comparing the first and the second edition of your book. to me, it seems that in the second edition, Lone Fuller plays a very important role, and all this idea of legality, and maybe even res, that now in your lecture, I think you made very clear that also res and this idea of legitimate authority, it's very important for you. But I think that what's at stake here is the idea of morality. To me, and I'm Habermasian, so I have no problem in saying that, to me, morality is always thought in intersubjective terms. And I think that the working provides a better account of the intersubjective dimensions of judicial moral obligations. The petitioner starts raising a moral claim, and the judge has to answer to that. When you turn to Fuller, the impression I have is that, maybe I'm wrong, but the impression I have is that you turn judges into moral monads. So they have to analyze, oh, this is not law, this is not, there is some legality lacking here, but then you miss this intersubjective dimension of the moral obligation. So concerning the Nazis judges, the working could say, okay, you don't have adjudication, they are not engaging into a moral dialogue with the petitioner and with other judges and other courts. So I think that even as a description of what's going on, I think the working idea is very powerful, and to me that's why he doesn't need this legality theory. I would like to hear you about that. And the second question is somehow related to that, since I mentioned John Dugard, and I really enjoy his writings a lot. I think he's like a great law professor. You showed in your book that South African judges, they had to rely on common law since they were in the wicked legal system as a way to kind of escape and bring moral content to their decisions. I would like to hear from you if you think that international law can play a similar role, because we don't live in a common law country. So what's the role the international law and this moral international standards, could put this way, could play into this, into judging in weak legal systems that do not have this common law connection?
Okay, so I might try to answer both of your questions at once. And I'll start with this, the person you mentioned, who was my main mentor at law school, John Dugard. Dugard is best known for being an international lawyer and didn't think of himself as a legal theorist. But he taught legal theory at my university because he thought that legal theory was too important to be left to others. So it was the case in my law faculty that most of the law professors pretended that apartheid didn't exist. And the one senior law professor who took notice of the fact that we were living in an apartheid legal order was John Dugard, and he wanted to show why legal theory was actually relevant to thinking about the problems that faced South African lawyers and those whom at least some South African lawyers were trying to help, which is why he taught legal theory. And one of the things that Dugard taught me, he taught me both international law and legal theory, is that we should spend a lot more time on Fuller than people generally thought. And so I was always, to some extent, a Fullerian. I always thought there was something to this idea of the principles of legality. And I think one will find this thought in the first edition of my book, and maybe it becomes more prominent in the second edition. And but this idea of principles of legality is, as I mentioned in my presentation, dismissed by both legal positivists and Dworkin. And in fact, the only real compliment that I ever got from my supervisor Ronald Dworkin was he said to me at the end of my doctorate, I was a tough student to supervise, so it wasn't surprising to me that I only got one compliment, is he said that I'd almost made him think that there was something to Fuller, almost made him think, but hadn't quite succeeded. So why do I think there's something to Fuller? I think Fuller is important because Fuller helps us to understand why what you call this intersubjective relationship that Dworkin focuses on, why that is made possible within a legal order. I think without Fuller, one can't actually understand why, as a matter of fact, judges will be able to give answers to questions which preserve the intersubjectivity of the relationship between legal subject and those who make the law, as well as those who interpret and apply the law. So I think Dworkin is really important, and that's what he highlights. But I think what he leaves out is just as important, because it helps us to understand why the Dworkinian element is possible at all. So let me try to explain this not in terms of Dworkin, but in terms of Hart. Because as I've said, my project now is in large part rethinking legal positivism and trying to extract resources from Hart's legal theory that I think Hart's own students like Raz neglect. Hart has an interesting structure to the way that he presents things. One sees this in his 1958 piece, and one also sees it in the concept of law. In the 1958 piece, he first deals with theories of interpretation. How should we understand the situation in which there doesn't seem to be a clear legal answer to the question, what is the law? Then he moves on to deal with Radbruch. And once he's disposed of Radbruch in the manner that I described, he then goes on to deal with the kind of problem that Fuller was to elaborate. How should we make sense of the thought that there are in legal order principles of legality that somehow condition the content of law? But he never takes into account what happens if a judge is faced with the question, what is the law? And in answering that question, has to take into account the principles of legality in answering that question, because he always assumes a static model of legal order when confronting the relationship between law and morality, in which what law is always determined as a matter of fact. And then the question is, what sense should we make of law from the external perspective of morality? One finds exactly the same structure in his great book, The Concept of Law. Hart sets out his theory of law in the first 7 chapters. In chapter 8, he turns to the question of the relationship between law and justice. And in chapter 9, he turns to the question of the relationship between law and morality. And in that chapter, which is much neglected in philosophy of law, Hart sets out his account of what he calls a minimum content of natural law. And Hart claims that in any legal order, it will be the case that at least some people's interests are served by the law, because if no one's interests were served by the law, we would not have law. But he thinks that this class of people whose interests have to be served by the law could be confined to a small group of the population. The rest might find the law totally oppressive. And so he can preserve this thesis that I mentioned right at the beginning of my presentation, the separation thesis, that there's no necessary connection between law and morality. But if one adds into Hart's legal theory not only his account of the fundamental rules of the legal order, notably the rule of recognition, but also the principles of legality that he on occasion will acknowledge are part of every legal order, and I'm happy to talk more about this issue, and one adds in further the claim that there, in any legal order, at least some part of the population has to get the kind of protection that Hart associates with the minimum content of natural law, then I think one has a much more complex account of legal order than legal positivists are usually supposed to put forward. And then there's one further thing that I think one can add into this picture. At a late point in Hart's chapter 9, in the concept of law, he talks about something, a topic on which he only spends a very few lines. But in these very few lines, he says that we might think of a phenomenon in legal orders that pertains to what he calls the judicial virtues. What are the judicial virtues? The judicial virtues are that in any case in which there's a genuine question about what the law requires, judges should try to answer that question by looking for a general principle that can support a general principle that makes sense of the positive law, that can support the answer they're going to give to the question, and that will serve the interests of those who will be affected by the judge's answer to the question. So in these few lines, I think Hart, in a strange way, but interesting way, sketches the kind of legal theory that Dworkin was later to develop in his account of hard cases. I think it's significant that Hart calls these judicial virtues, not judicial duties, because I think, as it's been pointed out by Jeremy Walden in a very interesting article about Hart's response to Fuller, Hart had a kind of very ambiguous response to certain challenges. So with Fuller, he would say, well, there are these, on the one hand, he would say, there are these fundamental principles of legality, but they make no moral principle. And he would say that in one criticism of Fuller, and then in another criticism of Fuller published separately, he would say these fundamental principles do make a moral difference, but you shouldn't think of them as fundamental principles of legality. Why? Because a legal order can be a legal order without living up to these fundamental principles. But if we put this complex picture together and disambiguate Hart so that we think of what he calls the judicial virtues as a judicial duty, and as the fundamental principles as principles of legality, which are moral as well as legal principles, then I think a judge who is dealing with a concrete case and looks at the positive law and sees that one answer that the positive law seems to suggest, maybe seems most obviously to suggest, is an answer that has to treat the legal subject not as a legal subject, but as an object, and the object of a gunman situation writ large, that is, as the object of an exercise of coercive power rather than of legally authoritative power. Then the judge has to try, as a matter of duty, to try to find an answer that will vindicate law's claim to authority, and not only a claim to authority, but a claim to have legitimate authority. And then the further point I want to make, which is the point that I made in answer to Conrado, is that if a judge is unable to do that, that is, give an answer that can be made in the voice of authority rather than sheer power or might, if the judge is unable to do that first thing, then the judge will find that the judge is not operating in a legal order anymore, but is operating in a kind of bureaucratic system which looks like the gunman situation writ large. So I want to tie that, so that all of that complex stuff that I want to feed into Hart's theory is necessary in order to make it possible for a judge to preserve the relationship, the intersubjective relationship between lawgiver and subject of law. So that's the answer to the first question. Answer to the second question about international law. I mentioned that I took international law as a student from this fellow John Dugard, but I never studied international law thereafter and have never taught international law. But this has been one of the great regrets of my life. I'm what you might say in English is a wannabe international lawyer, because I find international law much more interesting than most fields of substantive law. And that's because I think it's the case that when we look at international law, we have to try to understand the question, what is law, in a way that removes some of the major resources that we rely on in trying to understand the question, what is law, within a national legal order. That is, we remove the institutional order that we take for granted in national legal orders. That is, the institutions that we associate with the separation of powers, legislature, judiciary, and executive. And that, so in international law, the fundamental questions of philosophy of law become even starker, I think, than they do when we approach them, say, from within the perspective of Brazilian law or Canadian law or even apartheid law. So in what way does international law provide a resource? Well, I think it does provide a resource, especially in legal orders which consider themselves to be monist rather than dualist. And while I know very little about the Brazilian legal order, I would assume that the Brazilian legal order is a monist legal order, because I think that all legal orders in this part of the world, I might be mistaken about this, are monistic. So it's taken for granted that if you have a legal order, that the principles of international law are in some way automatically part of the fabric of your legal order. Now, of course, it's the case that a legal order might, through deliberate enactment of positive law, move away from those standards. But it's also the case that a legal order, which has constitutionalized rights, can use enacted law to try to move away from those constitutionalized rights. So does this give judges a resource? Well, it does give judges a resource, because, so I'm again reverting to my answer to Conrado, judges can make very explicit that what the legal order is doing through the machinations of those who happen to hold political power is moving away from a scheme of values or principles or rights, whatever one's going to call it, that they consider to be valuable, and that those who are subject to law should consider to be valuable. And then ultimately the limit situation is in the hands of the people who are subject to the law, whether they want to be ruled by law or by some other means. And I think the same is true of common law legal order, because there the principles are just implicit in the law, but judges can make them explicit and point out when enacted law is moving the legal order into being something else. And I think that it is the case, as I've said, that the further one moves the order away from these constitutional standards, that the less the order will seem to be a legal order. And just one last thought, which I'm happy to say more about. I think that this debate in international law theory between monists and dualists is a kind of fake debate. Why? Because I think dualism is not actually a theory of international law. It's a stance that some countries take in regard to international law. And it's a stance which says that the obligations of international law will only have domestic effect when they're incorporated through a statute of the legislature. But that's just a mechanism for making those obligations effective. Those obligations exist in international law before they're made effective. So the difference between monistic and dualistic orders is a matter of the mechanism for making the standards of international law effective. So any legal order that moves away from those standards, even a dualistic legal order, is, I think, betraying fundamental legal commitments, and it's the job of judges to make that clear.
Thank you. Murata. Anybody else after? I have a question, but I don't want to abuse my position of having the microphone.
First, I'd like to thank you, Professor, for your lecture. It was really, really interesting. I have actually two questions. I'll try to be as brief as I can in order to let more people to make more questions. The first one regarding your criticism of legal positivism. One thing that I would like to hear you more, it's about what we can say of in commas layers of normativity. It's one thing to say that I have a judicial obligation to do something. Another thing is to say that I have a moral or ethical obligation to do something. So we can speak of a judge having a legal obligation to apply the law, or we can speak of the judge having a moral or ethical obligation to do that. And those questions, they are not the same one. And I think that they might, this distinction might help the positivists to tackle the problems you have mentioned. Because if you look at Hart or even Ras in practical reason norms, the judge is supposed to take the legal point of view and apply the law, in RAS at least, because the law is made of exclusionary reasons that should be applied without moral review of the legal rules. And you have this split between ethical and legal stances in RAS and Hart's more ambiguous on this, but on RAS you actually have this distinction, at least in practical reason norms. And I'd like to hear a little bit more about this point. The second one is about working. I can't remember now the text. I think it's on the preface working rights for a book about South African law, and he mentions this. He tells that as a sort of a joke. He heard on a train a woman talking to another woman. One of those women were in distress. She was crying, and she says to the woman that is not crying, she says to the woman crying, "Well, you should be philosophical about it. You shouldn't think too much about it." And Dworkin takes this story as a Wittgensteinian stance he believes applies to the problem of wicked legal systems. What he was trying to say, if I'm not mistaken, he was trying to say that, well, people are giving a lot of thought on this problem of wicked legal systems, but actually, when Fuller says, Hadbrook says, unjust law is not law, and when Hart says, unjust law is law, but bad law, both propositions make sense. And the thing is, both make sense because maybe Hart and Fuller or Hadbrook, they're using different concepts of law. They're not using the same concept in the same sort of language games. And this is why there's a lot of confusion. People that are using the same word, thinking they're talking about the same concept, but they're not talking about the same concept. And this is one of the reasons, at least as I had read it, that makes Dworkin introducing Justice in Robes and then Injustice for Hedgehogs, this distinction he makes about different kinds of concepts of law. And this is something I'd like to hear you about. And another thing about Dworkin is that if you look at Law's Empire and even at Justice for Hedgehogs, Dworkin presents his theory, mostly in Hedgehogs, of his theory of law. He claims that law is a branch of morality. You don't have two systems that are connected. You have just one system, and law is a branch of this bigger picture that is morality. And when you look at what we're saying about how moral principles can be internal to law, I'd like to hear about you, to hear from you what you think is the difference between your picture and this late Dworkin picture that actually gives a more dynamic feel within law than his previous ones about hard cases. At least it seems from Law's Empire onwards that Dworkin is not so worried about hard cases, but is more worried about the kind of concepts and disagreements you have in law than about specific cases. That's it.
Yeah. You want to?
Sure. So again, two really fundamental questions. So let me start with Hart and Raz. And this brings me to the topic which I mentioned in the presentation, but then moved away from, the distinctions between Hart and Raz when it comes to the issue of understanding law's authority. And you'll recall that I suggested to you that I think there's a lot rides on the following distinction. That is that Hart, in my view, wants to understand law as a matter of authority, which is why he doesn't put his argument in terms of law making a claim of authority, but in terms of an argument which tries to elaborate the authority that law has. And then in contrast, Raz always puts the argument in terms of a claim that law makes, and then says that we should understand that when law claims authority, or more accurately, when the officials who staff the institutions of law claim authority, they also necessarily claim a legitimate authority, even if that claim is wrong and even if they're insincere. And I mentioned that Hart is very worried about this injection of legitimacy talk, which doesn't concern Raz because he thinks he can always add the rider. And of course, the legal order might be completely illegitimate. The exclusionary reasons, when we look at their content, the content might be so awful that we just say law's claim to authority should be dismissed out of hand. Right, so that's the setup of the problem as I understand it. So I don't think Raz faces the same issue that I think Hart faces, because Raz does not think, as Hart does, that the law always has authority. And if although I think Raz is deeply ambiguous about this issue, and in the paragraphs that one reads about this, he'll never tell you what he thinks. And I say this with the greatest respect for the man, and perhaps I should mention that I had the great advantage not only of having Ronald Dworkin as my supervisor, but because Dworkin was half the year at New York University, Oxford was forced to give me other supervisors in his absence, and the person I worked with most intensively besides Dworkin was Raz. And I have the utmost respect for the man, but I think that he's thoroughly ambiguous on this issue, whether if law fails to have legitimate authority, whether therefore law not only lacks authority, but also fails to be law. Hart doesn't have that problem, but he has a different problem. Why? Because he thinks that where there's law, law always has authority in some sense. Now, when Raz introduced this idea of legitimate authority, he relied a lot on Kelsen. Now, I understand from my colleague, who is a graduate of this university, Mariana Prado, that when you're taught jurisprudence in Brazil, what you mostly learn is Kelsen, which I used to think was probably a bad thing, but now in my later years, at the same time as I've become a wannabe international lawyer, and this phenomenon is not disconnected from the other phenomenon, I've also become a Kelsenian. Because I think that Kelsen is probably the greatest legal philosopher who ever alighted on this earth. I don't know about any other legal philosophers. And I find very interesting Raz's Kelsenian side. So why does Raz introduce Kelsen? Now, Raz's reliance on Kelsen is not a reliance which many Kelsenians think gets Kelsen right. But I think it gets Kelsen right. Why does Raz think Kelsen is important in this debate? Raz supposes that Kelsen is important in this debate about authority because in order to understand law's authority, one has to presuppose a figure whom Raz in The Authority of Law calls Kelsen's legal man. Who is the legal man? The legal man is someone who regards the law as exhaustively containing the standards of correct morality or justice. And one needs to presuppose this legal man in order to understand law as a matter of authority. Now, Raz thinks this is no problem for philosophy of law for a reason similar to the reason I mentioned earlier, and that is one can presuppose this legal point of view, the point of view of the legal man, without thinking that one should morally endorse the content of that point of view. And Raz's famous and very effective example is as follows. He says, imagine that on the one hand, you have a devout Jewish person, but who's, while devout, is completely ignorant of the laws of Judaism. But this Jewish fellow has a Catholic friend who happens to be very knowledgeable about the laws of Judaism. The Jew asks the Catholic, what should I do? And the Catholic tells his Jewish friend, this is what you should do. In order to tell the Jewish friend what he should do, the Catholic has to presuppose the point of view of the Jew, which is a view that endorses the laws of Judaism, but doesn't have to accept that point of view. And Raz thinks that as long as one makes that distinction, one can preserve the fundamental theses of legal positivism. I don't think one can take the point of view of the legal man as Raz understands it and remain a legal positivist. Why? Because if one has to accept that, if one has to presuppose that point of view, one has to try to make sense of legal order from that perspective. And in order to make sense of legal order from that perspective, this goes back to my answer to the earlier question, one has to load in all of this stuff about legality, minimum content of natural law, judicial virtues, and so on. And then one can actually make sense of this claim that the legal point of view that Raz presupposes is not merely a legal point of view, it's also an ethical point of view. It also is a moral point of view. And I think one can hold on to this distinction between law and morality, but not the distinction that legal positivists want. What is the distinction? I think I can make sense of the claim that law has a moral claim on me and still think that the content of the law is so morally unjust that I should disobey that law. Or I think one can make sense of the claim from the perspective of a judge that here is the law that I have to apply. It's my moral duty to apply the law, but I experience a conflict of duties here because I regard this content of the law, even though it has some moral quality to it, as in the end deeply unjust. So I should not apply the law. And I think this is often the way we think about moral conflicts. And indeed, when Fuller responded to Hart in 1958, he said that he didn't understand Fuller's critique of Rudbrook because Hart claimed that legal positivism was better able to respond to difficult moral problems, moral dilemmas, than natural law theory. But Fuller, as he understood Hart, said that Hart's response was, on the one hand, we have a moral demand, that's the demand of morality. On the other hand, we have the demand of law, but that's a normatively vacuous demand. And how can we make sense of this as a dilemma? If there's going to be a dilemma, there has to be morality on both sides. And in order for there to be morality on both sides, just because there's law there, law has to have some moral quality to it. So just one last thing to say on this issue. If you look back right to the beginning of Hart's 1958 essay, he endorses a slogan that he takes from Bentham, where Bentham says that the mark of a good citizen is to obey the law, but then to criticize the law freely, to censure the law. And Hart doesn't seem to notice at this point that Bentham's idea of the good citizen is someone who accepts that there is a moral duty to obey the law, though he should feel free morally to criticize it if he disapproves of its content. And that is a kind of hidden theme, I think, in Hart's legal philosophy, and I want to try to make that theme more explicit. Okay, Dworkin. So this, I find the introduction or preface, whatever it's called, to this volume of essays really interesting. So just to give a bit of background, despite the claims that legal positivists made that if one looked at the apartheid law, legal positivism had to be right because apartheid law showed so clearly why Dworkin was wrong, this view was not shared by South African lawyers who were on the morally right side of things, including this fellow we've talked about, John Dugard. The main inspiration for South African human rights lawyers was Ronald Dworkin. So after the end of apartheid, a group of such lawyers invited Dworkin to come to a conference in South Africa in order to discuss this rather puzzling phenomenon that Dworkin was considered to be the most helpful theorist when it came to resisting apartheid law. And Dworkin, as is usual, had not written anything in advance. He just said what he thought was interesting at the start of this conference. And that actually constitutes this preface, because it was a transcript of what he said, and he agreed to have this transcript published as the introduction to the conference proceedings. And one of the things that I think is really interesting about this speech of Dworkin's is that you can find all of the elements of Justice for Hedgehogs in that speech. Now, Dworkin's view is that one can, as you put it, that one can, of course, change the subject. One can ask whether the Nazis had law in what he calls in his introduction to the volume of essays you mentioned, Freedom's Law. One can adopt what he calls a sociological concept of law. I'm afraid by the end of this, you're going to think that all of my answers to the very different questions are the same answer. But and if you think that, you're going to be right. which might give you pause in your decision whether to come tomorrow and the next day, because I really have only one thing to say, I should confess right now. So Dworkin, in the introduction to the Collection Freedoms Law, and then in a later chapter, sets out a kind of taxonomy of concepts of law. And one of the concepts he identifies is a sociological concept, which he attributes to Fuller, and Fuller's idea of principles of legality. And Dworkin says one can ask the question, is a legal order if it fails to live up to something like Fuller's principles of legality? And he says, well, that might be interesting for sociologists, but it's not interesting for philosophers of law. It has no bearing on the questions that philosophers of law face. What is the main question that philosophers of law face? The question is, what is the correct doctrinal concept of law? That's where the action is, according to Dworkin. What is the doctrinal concept of law? It's one's theory of law that tells one what one's legal obligations are in any legal order. So Dworkin, from the beginning until the end, so from the preface to Taking Rights Seriously until Justice for Hedgehog, relies on a distinction, which I think is a very interesting distinction, between one's legal rights and the other sorts of rights one might have. Sometimes he calls these legislative rights, sometimes he calls them moral rights. But the difference between legal rights and the other sorts of rights is that with the legal rights, you have them on demand from some legal institution. You don't have to go, say, for example, to a legislature and ask the legislature to create these rights in the law. They're the rights you have that are already in the law. That's why you can have them on demand. And the theory that tells you what these rights are is a doctrinal theory, because it tells you what the correct proposition of law is when it comes to answering the question, what is the law? That's where the action is in philosophy of law. Dworkin identifies a third concept of law, which he calls, and he doesn't mean this as a compliment, a scholastic concept, and that he attributes to Raz because he thinks that Raz just starts with some weird theory of authority and generates an account of law out of that, which then disqualifies other theories of law. But Dworkin thinks that's a bad place to start theorizing about law, because one should theorize about law in the midst of practical questions about law, which is why he alludes to this conversation he overheard on a train. So Dworkin is generally allergic to starting the answer to the question, what is law, from outside of the law, from some meta standpoint, in the same way as he's allergic when it comes to discussing questions of morality to any kind of meta-ethical theory. All these questions are to be resolved within actual practices of argumentation, which is why you might think of Dworkin as some kind of Wittgensteinian, as you suggested. So we have three concepts of law, right? Sociological might be interesting for sociologists, not interesting for philosophers of law. Doctrinal concept, because that's where the action is in philosophy of law. Scholastic concepts, which we can dismiss because they're just some kind of game that some legal philosophers like to play, have nothing to do with the real life of law. And then there's a fourth idea, which Dworkin, I think, doesn't call a concept, but a conception. And he says this is an aspirational conception, and he calls this, it has to do with legality or the rule of law. But he calls it a conception, not a concept, I think, because he thinks that one can read off any legal theorist's aspirational conception from the doctrinal concept. So for Dworkin, what the rule of law is the rule of substantive principles of liberal morality. That's the rule of law for Dworkin, which is why he doesn't need an independent concept of legality. He just needs a conception of legality that one can derive from his doctrinal concept. When it comes to legal positivism, which is why Dworkin, contrary to the legal positivist, thinks that he's in a genuine debate with legal positivism, the positivist doctrinal conception of law can similarly, positivist aspirational conception of law or of legality can be read off the positivist doctrinal concept. Because positivists think that law is a matter of rules with a determinate content, that is, they have this static idea of law that I mentioned during my presentation. They also think that judges, when they decide hard cases, should try to find law with a determinate content of that kind, right? So one then has judges of the sort that I describe in my book as plain fact judges, again a term that I take from Dworkin, who try to make the law live up to a positivist ideal for law, which is to have law as a matter of rules with a determinate content. So there you get positivism's aspirational conception of the rule of law, something which positivists always denied. Now, this is why my answer to this question is the same as my answer to previous questions. I think that Dworkin's doctrinal concept of law cannot do without what he dismisses as the sociological concept of law, that is the principles of legality. Because it's having the principles of legality in place that makes it possible for judges to operate with what Dworkin regards as the interpretivist doctrinal concept of law. Without that, one cannot have that kind of practice of interpretation. And I think, by the way, that the same is true of international law, even though international law lacks the institutional makeup of national legal orders. So that's my answer to the second question, which, as I said, is the same as my answer to previous questions.
Okay, any more questions? Actually, my question was contemplated in the first question of Murata, so I won't go through making it repeated for the third time.
I'll try not to repeat my answer for the fifth time.
Okay, yeah. No. Anybody else have any other questions? No? Okay, so I want to thank you very much for attending today. We hope to see you all again tomorrow for the second lecture, as well as Thursday for the third lecture. If anybody has any books for signing, now is the time. Okay, so thank you so much. Thank you, Professor Dysenhaus, once again.
Thank you very much.